Yeah,
All
you're
right,
welcome.
everybody. Well, welcome back for our final presentation of today's session. As I mentioned right before we concluded for the break, is on internal investigations. So I'd like to welcome in Susan Motschiedler. Susan is a member of the firm's Employment and Labor Law and Litigation Practice Groups in the Salt Lake City office, where she counsels clients on a wide variety of employment law matters. So Susan, thanks for being with us today. Welcome. It's nice to have you. I'm going to turn the time to you.
Okay, thank you. Glad to round you out here at the end. So today I'm going to talk about conducting an effective internal investigation. If you forward to the next slide, Jason, thanks. We're going to talk about five different topics. The critical investigation triggers, what the scope of your investigation should be, best practices for interviews and evidence collection, memorializing and preserving what you have collected, and then legally and efficiently remedying the problem. The one assumption that I've made for today is that you have already evaluated, after realizing that you need an investigation, you have evaluated whether or not to bring in outside counsel, and you have determined to do it internally. And that could involve your in-house counsel. So there could still be some privilege issues. And if we have time at the end, I'll chat a little bit about some of those. But in general, this is directed towards human resources, potentially under the guidance of in-house counsel or with the involvement of in-house counsel doing the investigation themselves. And so, if I get the next slide, please. The first thing is what is going to trigger the investigation. So when should you investigate? And sometimes this is a little tricky to determine. And there are definite pieces of employee conduct that when you become aware of, or when you hear a rumor that potentially some of this has happened, you should definitely investigate. And the number one and two, actually, unlawful discrimination or harassment. So if there's any implication of discrimination or harassment of race, color, religion, sex, national origin, age, any protected status, that should most definitely trigger an investigation. It might be a minor investigation depending on the nature of the conduct at issue, but definitely those are such heavy hitters that you should document and conduct an investigation. Other heavy hitters are violations of statutory or legal obligations. And this is more in the area of financial fraud, securities, insider trading, espionage, if you do any kind of government secrets, or if you're a government contractor, or if you have any sort of medical secrets or protected information, which you have come to learn is either being stolen, compromised, shared, whatever, that should trigger an investigation. Next slide, please. Or theft, sabotage, any kind of workplace accident, particularly if there is an injury, or definitely if there's a death, or if it's something that OSHA or MSHA will be able to investigate, you will want to hustle in there and start your investigation early. Any incident of workplace violence should trigger an investigation. Drug and alcohol use might. Likewise, if it's widespread among many employees. And then there are also other investigation triggers that could implicate things like policies. And so say you have an anti-gossip policy, and you have a workplace that is a hotbed of gossip. That could itself implicate that particular policy. But then it could also implicate these other policies or other kind of larger overarching issues like discrimination or harassment. Oftentimes, when there is a violation of the gossip policy, it spills over and it's directed really towards somebody based on a protected class. So that might be an entry point, a violation of a more, I guess, minor policy, if you will, that could implicate larger laws with more liability. Next slide. These can come to the company's awareness of a number of different things, or a number of different ways. For financial fraud or accounting fraud, it can be your own observation or a controller's observation of the data. So you might get a report or a series of reports that look a little wonky, that need to be analyzed further, or there need to be some investigation or monitoring done. And at that point, at the point that you have somebody come to you with a concern, I would consider that the beginning of the investigation. And it would trigger obligations of preserving the data, and keeping records, and an awareness on your part that you are, in fact, conducting an investigation, even though for financial fraud, for example, it's going to be over a much longer time period, because you want to observe and see what's going on first. And something like discrimination or harassment is going to be a very short time period where you start interviewing witnesses and employees and that sort of thing. You can get an anonymous complaint on a hotline. I'm sure for those of you who have installed a hotline, you know that employees tend to use it to lodge all of their disgruntlements. The problem with the employee complaint hotlines is just that you have potentially de minimis complaints that you have to take seriously. But it's good that you take them seriously. There is a record of them. You should preserve them, and you should look into them and at least check it off. If it's, let's say it is somebody was irritated with somebody else on a shift and called the complaint hotline, and it turns out to be a de minimis resolvable issue that may already be resolved by the time you get around to it. You should still tie that off just as much as you would tie off a more serious type of complaint of harassment or discrimination. Employees can complain to their supervisor or other employees, or to human resources directly. You might get a customer complaint. So a customer may observe behavior at the workplace that would warrant an investigation. You may hear a rumor, or you may find out in a number of other ways. But generally, if you get a feeling that you should investigate, you should investigate. Or if you have a question, does this require an investigation? You can even do a little mini one and tie it off. Next slide, please. The next thing we're going to discuss is what you're going to consider. Like, what should the scope of your investigation be? And really, the scope is going to be determined by the nature of the investigation, and the scope of the problem itself. But in every investigation, you're going to start to have questions. Should I look at that? Should I not look at that? And you've got to prevent yourself from running down a rabbit hole of, kind of trying to tie off all the loose ends and determining what you don't need to look at. And so at every investigation, I ask myself, do I need this to uncover the truth? That's ultimately what we're doing. Do I need to look at this to determine what really happened, or is this duplicative, for example? Or have I already have 15 employees who have said the exact same thing? Do I need to interview 5 others? You also want to be able to prepare a legal defense down the road. So that's going to guide whether or not you interview those 5 other employees, or what type of evidence you seek to uncover, and how far you're going to go. Part of preparing a legal defense is realizing what type of exposure you have from the purported behavior or issue. You're going to want to preserve the evidence. That's another point of the investigation, and goal is to help you uncover the truth, to help you remedy the problem, to put it in somebody's employment file so that if it's an issue later on, you have a record of it. So it's really to prevent the same thing from happening again. But really, from my perspective, what that issue is you're preparing a legal defense, and you want to make sure that you can establish that you have done a defensible investigation, that you have preserved the evidence, and that you've also preserved the decisions you made along the way. You want to be able to, after the investigation, one of your goals is going to be able to stop the illegal or bad conduct. And so you'll be thinking along the way, how do we solve this? Are we going to need, um, you're usually going to need more training. Are we going to need an additional employee? Are we going to need more communication between departments? And so I always am thinking about those things along the way and taking notes about possible solutions. And then it's obviously to correct the problems um, that you're looking at. Next slide, please, Jason. So how do you reach the truth? I mean, that's really hard, particularly when there are people involved. People have a lot of different motivations to lie or to tell the truth, or they might have not necessarily nefarious intentions, but there might be other reasons why they're not fully truthful. Um, so to reach the truth, you need to gather enough evidence and interview enough people and try to remain impartial until you finish gathering the facts. And oftentimes, particularly if it's a highly charged or emotionally charged issue, I, I definitely feel myself as an investigator, kind of veering here and there during the investigation and during the interviews, and people can be very emotional. And even as an outsider, um, it's hard not to be somewhat swayed or have, feelings about that. But at the very end, what I'm doing is I'm gathering evidence and I'm going to look at it all. And if there are a number of interviewees, and particularly if they have different stories, I go back periodically through and I kind of re-review what everyone has told me to determine what else I need to do and where the scope is going to lead me. And you're going to want to carefully compare and analyze everything that you've gathered to determine what the weight says. And ideally, you're going to do that at the end anyway. But it doesn't hurt to make judgments as you go along. And again, like I said, record those judgments. And and even in looking back at the recording of why you made decisions, you may be able to make additional decisions or different decisions. And it helps kind of keep you moored along the way, um, particularly if there is a lot or if there are a lot of interviewees and a lot of documentation. Next slide, please. So what are you going to look at? Colloquial, I say people, places, and things. So witnesses, who you're going to interview, documents, what kind of documents you're going to request the witnesses give you, and what kind of documents you're going to obtain behind the scenes on your own or with IT, and then things. And so things could be, if there's a complaint that involves an object, you'll want to see the object. If you are investigating an injury, you will want to go to the place where the injury happened. Other things you might look at are like video surveillance tape. And I think on the next slides, we'll talk a little bit about these three different categories. So people, make a list of everyone who you think may have seen or heard details. And so some of this, like the heard details, there may be some gossip going around. And while that's not as good as eyewitness, it's awfully good to determine how your workforce is looking at this and kind of what the word on the street is. And you sort those into the two different categories. Those most likely to have personal knowledge of the critical facts. And those people you need to do face-to-face interviews with, most definitely. And then there are others where emails or phone calls may suffice. I generally don't like emails because you're creating another piece of evidence that doesn't necessarily need to be created. If you're an attorney, that's probably it could potentially be protected, or if you're emailing with your attorney, that's protected as attorney-client privilege. Typically, I do it when I need to make a record. So for example, if I need to get a document from somebody, and I email and ask them for that document, so that I have a record that I I know that this document we need to look at, and I know that this person probably has it, and I've asked them for it. And that's really the only type of information I put in. Or, for example, you can do it to determine whether or not you need to talk to this person face to face, i.e., were you this person's supervisor during these times, during these years, or did you ever write him up? That kind of really factual stuff to find out that person's involvement. Phone calls are, I think, the better way to go for some of these folks. Some of these will be people you just need to clear out. You need to document that you've talked to them. You need to make sure that they don't have any information. And a phone call is going to suffice. If this is a particularly gossipy workplace, I would not do a phone call. I would have that person come in, both to kind of get to the seriousness of it, and so that you can talk to them about confidentiality concerns and that sort of thing. Your list of who you're going to interview may change as you go. And again, I encourage you to keep notes as to why you make the decisions, because oftentimes it's apparent in the moment, but after 2 weeks of an investigation, you may forget why you made that decision in the first place. And so you need to be able to defend why this person does or does not have information. Next slide. At the beginning and the outset of potentially before you even interview people, you should make a list of documents that you think are going to be necessary. And so, for example, for like theft issues, are there any documents, logs, that sort of thing that are going to help determine whether or not a theft took place or how much was stolen or that sort of thing? Documents are going to include in almost every investigation, like policies and procedures. What policy has been broken? If it's changed recently, you might want past policies, or you might want to see the evolution of the policies. You want any statements or notes taken about the incident, and so that could be logbooks, that could be particularly like OSHA violations or OSHA investigations, witness statements right after an accident has happened, or logbooks about the incident. If there's a lockout tagout violation, you'll want to get the logbooks obviously from that. You'll want pictures of the lockout tagout area, that sort of thing. If it's like a sexual harassment or discrimination, you will want the personnel file of the accuser and the accused. I know it sounds a little bit bad to get the accuser's file, but oftentimes maybe they've made these types of claims before. Maybe they're super sensitive. Maybe there may be something in there. There might not, again. And likewise, the personnel file of the accused could tell you if this person has had, if this person has had any prior incidents like this. And then any incidents files involving prior complaints by the accuser or against the accused. Those might be separate from the personnel file as well. Manager's notes, if you have a logbook, for example, or if there are shift notes taken in a computer, that sort of thing, you'll want to pull those and preserve them. Personnel files of other critical witnesses. Oftentimes I have found in discrimination or harassment claims, people have strong feelings about what went on, even if they weren't personally involved. And people may have had strong feelings about past incidents. So it's good to know that before you interview them or after you've interviewed them, that this person may have a history of weighing in a certain side. And you'll want to take that into account when you interview them. So logs and diaries, time cards or security badge readings. So this will potentially help you figure out who your witnesses are, like who else was on the shift. Or I've used these to determine that the swipe card shows that the person was not even in an area when they were alleged to have done something bad in that area. Oftentimes when people make up lies, they're not always so smart about thinking about these details. And even though they know that they have to swipe in to get into an area, they haven't considered that when they're talking to you about what happened. And It's very easy to clear that out by looking at data, or if there's a video feed of that area, that's also good. Expense reports and receipts, so for fraud, that sort of thing. If you pull going back a couple of years, you may see a repeated pattern that was minimal, but that now has become bigger. Texts, emails, social media posts, that kind of thing. Your list is going to change as you go, and likely as you interview more witnesses, you're going to realize that there are more documents. And typically, if I need to talk to a witness about a document while they're right in front of me, I ask them to pull it. And then I have copies made of it, so that it's not something else that's on my list of things to do. I just take care of it right there. Next slide. So things and locations. This often will be a works-cited visit, or something like that. That's typically as I said, an injury. And as an investigator, particularly if you have a lot of different locations and you may not know them by heart, it helps to walk through the workplace and to walk through the events as they happened. And this can be helpful in injuries, but also incidents of sexual harassment, or if there was a physical assault, to see, or an accusation of a physical assault, to see if it's even possible the way it was described to have happened. I have interviewed people before where they described what they said was an assault, and after walking through the physical layout of the area, I pretty quickly determined that it was impossible to have happened the way the person was telling me it did, because the people weren't physically close enough to each other to have touched each other. Um, and so, we were able to successfully overcome, a claim of discrimination, or sorry, a claim of harassment and assault, just by understanding the physical layout of the area, that it just wasn't possible. Surveillance tapes are also helpful. Phone recordings can be helpful, or voicemails. Text messages are another thing, particularly, I think in a couple of other presentations today, we've talked about the company's ability under their policies to go into an individual's phone and get text messages. And if you have an employee with maybe two phones, like a personal phone and a work phone, I still sometimes ask during an investigation if they'll show me the messages between them and the other person, for example, or other people. And oftentimes they will willingly show that. So should you interview the witnesses or gather the evidence first? And it really depends on what kind of investigation you're doing. If it is a harassment or discrimination investigation, I would hustle and interview the complainer as soon as possible. It shows them that you are taking it seriously, that you care about their issue, and also you really need to put this to a stop as soon as possible. There may be other witnesses too who need immediate attention, who are, perhaps more up in arms about it than the actual victim of an assault, for example. For allegations, to juxtapose that against allegations of ongoing fraud or financial theft, that sort of thing, you're going to want to create a record and really know what's going on before you interview the accused. And you can get information from other witnesses as you're going on, but you really want to create a record first. There are also concerns regarding spoliation. And if you have, you should always have concerns regarding spoliation. And so destruction of evidence, or on the flip side, it can also be creation of evidence that is false. You should work with IT to preserve evidence immediately. If you can send out an information hold internally without tipping your hat to the investigation, I would do that. Oftentimes, if you need secrecy, you're going to have to work with an outside vendor, perhaps, if your internal IT group is compromised or otherwise untrustworthy. You will want to create backups of data. And you can also consider using a forensic company. And the benefits of using a forensic company is going to be that they have no horse in the race, first of all, and they will be able to provide expert testimony should it need to come about when if something goes to trial, for example, or if something goes to investigation before the EEOC or the UALD. Um, for IT, the same thing applies. They could also potentially be witnesses in a lawsuit. But you'll want to identify what you're doing as you're doing it and keep a log. Oftentimes, I know IT would like to move pretty quickly and doesn't always make a coherent log of what they've done or why they've done it. And so to preserve that evidence, I typically try to, so I understand too, I do more or less, not quite a declaration, but I have them write down the steps that they took and why they did it. And if they didn't do something and they made a decision not to do something a certain way, I have them document that as to why. Okay, next slide, please. You'll have to decide what the order of your witnesses is going to be. And if you do have a claim of harassment or discrimination, you'll want to interview the accuser first, or the person who allegedly has been harassed or discriminated against first. And that's primarily just to get the lay of the land and the story to dictate what the scope of your investigation is going to be. But it's also so that you can tell the person and show the person, like I mentioned before, that you care about their problem and that you are dealing with it now. You don't want that to escalate and have them go outside the company to self-help or to file a charge. You want to keep that in-house initially or permanently and resolve it internally. And so you need to move fast to do that. I also do witness outlines. And so you may have to interview your first witness without really having much of an idea or without having an outline. But after you interview that first person, you should have at least a very basic outline. And that can evolve as you go on. I include standard comments and questions. So since I'm an attorney, I give an upjohn warning, which means that I say, hi, I represent the company and not you. That's the essential piece of information I get across. And then, so they'll talk to me. I try to make it somewhat funny and say that means I can't give you advice about your will, your trust, your estate, your landowner dispute, your family law issue, disputes with your neighbor about their dog. I'm here to find out what happened, and I just represent the company. And so I can't offer you, just like I can't offer you advice about your dog or your neighbor's dog, I can't offer you advice about this particular investigation. And those are general questions. How long have you worked here? That sort of thing. And then witness specific ones, things I definitely need to get out from this witness. And the format that you're going to use is really dictated both by what works best for you and if there are any questions that you really need a specific answer to. And if there is something that I need that has to be phrased a certain way, or there's a legal standard that I'm going to have to meet down the road, I type out my question. I know this is very specific, but in pretty large font so that I can read it clearly, and so that it stands out as something I must ask. And I have them answer the exact question as phrased. Otherwise, typically, I can have broader topics. I find that a more conversant investigation will elicit better responses from people. Not always, but it can be specific questions. Were you there at 9 a.m.? Or, tell me about your day. When did you come to work? And if it's before 9 a.m., to walk through their day so that you're going to get to the 9 a.m. time slot, but you don't have to specifically call it out. It could be some combination of those two. Sometimes you have to start soft with a witness because they're very nervous. Even if they have done nothing wrong, they're just very nervous. They don't like talking to a lawyer and they don't like talking to human resources. And so you have to be respectful of that, and it does not mean necessarily that they're lying. And then I do prefer open-ended questions as part of my mix. People hang themselves on these often. Um, Sometimes you're not going to be able to get anything from a witness, but oftentimes they provide you a little bit more information, and you can go off into another topic with that information. Then I often get asked whether or not um, you should have signed witness statements, and I I typically, if I think someone's lying, I will have them sign a witness statement. And if they change it, I have them initial, and maybe explain why they've changed it. But the problem with signed witness statements, if you do them for one, you should really do them for all. But typically, almost always, when I think someone is lying or not telling me everything, I do a witness statement and I have them sign it, and oftentimes that can jog their memory. Next slide, please. Um, like I said, if it's interview the complainant first and promptly. You do not want the problem to get worse, and you really do want your employee to know we take this seriously and we are doing everything we can. And it also sets the expectation about how the investigation is going to go. And I usually try to explain to them um, how long I think it's going to take. It might take a while. I ask who they think I should interview. I usually ask them what they think should happen. And oftentimes that will um, that will change the scope of the interview, because in sometimes or the sorry the scope of the investigation. Sometimes it turns out that the person really just wants to be heard, and they're not on. They don't want to burn the house down. They do want some action taken, but they're not unreasonable. And I like to know that from the beginning. I also like to tell them what I'm going to be able to tell them at the end of the investigation. So oftentimes people want to know, the down and dirty of how somebody was disciplined, and you can't necessarily tell them that. And I tell them that at the very beginning. I will be able to provide you X, Y, and Z. Here's what you will not get. Um, that sort of thing. And then I ask them what documents, or I ask questions to lead to me to answers of what documents we need to look at. Next slide, please. Interview the other witnesses. And I know this sounds obvious to most of you, separately and never as a group. I have stepped into a situation before where the manager and a higher up in the company, very high up in the company, decided that there was an issue that needed to be immediately solved, and so this person called everyone in and interviewed them all as a group, and it really messed things up. Most of you will realize that that's probably a terrible idea, and it is. Everyone should always be interviewed alone um, and allowed to tell their own story so as not to influence others or intimidate others. And then as you're going along, after you've interviewed the witness, you'll probably want to update your witness outline, and you may have to also keep a list of questions to call witnesses back in, um, so that you can ask them other questions as well, and that's fine. Um, Typically, I interview the accused last. There's a risk that they're going to try to influence the testimony of others. If if it's a situation where there is theft, for example, um, I try to keep that completely tamped down and build a case against this person if that's where it's headed, before I interview them, so that it will be really hard for them to wriggle out and deny it, and it'll be really hard for them to destroy evidence. Um, and often you also might have to go back and confront other witnesses when you have gotten a different version of the facts, and that's fine too. Very rarely does it need to be immediate, but sometimes it does. Next slide. Like I said, you'll want to provide an upjohn warning if you are an attorney. You'll want to ask that they keep it confidential. And most of the reason that you want to well, there are two reasons really, but You want to preserve the integrity of the investigation. And I think every witness who might be otherwise inclined to share their experience understands that. And then also, you don't want a big problem in your company, and in particular, if you have a gossipy company, you'll want to clamp that down. You'll want to talk about the witness's background. You'll want to talk or determine how credible that witness is, and look for reasons for them not to be, or look at the reasons where they may not be. And that can be bias, they can be friends, friends with the accuser, friends with the accused. You'll want to look at the basis for their information. And so, you often have witnesses who are very clear that X, Y, and Z happened, but maybe they weren't there, or um, perhaps they need to give you the precise wording of what was said during that time, and your understanding of the words may be different. So you'll really want to get as much objective information from the witness as possible. Next. You want to talk about the incident, if there was an incident. You'll want to talk about any kind of documentation that the witness has. You'll want to see if they think that there are other witnesses, or if they can identify any other witnesses. And then in closing, you'll talk about confidentiality and why that's important. Retaliation concerns. And sometimes this is important, sometimes it's not as important, depending on, I should say it's always important, sometimes it's more important, sometimes it's less important. For Title VII issues, it is very important, or for other ADA, other statutes that have retaliation, that have really strong-toothed retaliation provisions. You'll want to make sure that the person knows that they either cannot retaliate or cannot be retaliated against, that they can report it, that you will act immediately, and that retaliation is illegal. And you'll want to tell them how they report it very specifically. And in some cases, you will want to provide them your information, or as an attorney, for example, I provide them my information because I know that the risk of retaliation is so great that they need to be able to call me immediately if it happens. And then if you're talking to somebody that could be a potential retaliator, you put the fear of God in them against doing that, and talk to them about the ramifications of what will happen, but also potentially what could be considered retaliation, so that you don't want to see any other people on a different shift, that sort of thing. If they continue to be a supervisor to certain people, you may disallow them from writing someone up, for example. And so another manager may need to step in case a write-up needs to happen, that sort of thing. So you may need to separate some people during the interview process. And then after the interview, I edit the outlines as needed, like I said, to update them for what that witness has given me. Okay, next. You'll want to issue a document hold, which automatically suspends any kind of destruction of documents. If you can notify the custodians, do, so that they don't do anything, and so that they're also preserving any other areas. Ideally, you will have a central document management system and a server. But there are situations, like we all know, people's phones, for example, you want those preserved, any writings, you want those preserved, voicemails, anything that the custodian might have access to and might be inadvertently or not, or intentionally destroy. You'll ask witnesses for the relevant documents and document what you have done and who you have talked to. If you send out a notification, you'll want to save that as part of the file. You can also make copies of people's computers at the time of your investigation. And a word about copies: make copies of the documents and don't take an original to the interview. I am willing, I write on documents all the time, and so I never should have an original document with me, and the witness should never have the original document. If they hand you something, just go out and make a copy of it immediately. You'll want to retain all of the documents and retain them by custodian and who gave them to you. And if you have a document that has a number of different custodians, let's say an email chain, if you have witness files, I would keep a copy in each of those witness files, so that if you need to pull somebody's one witness file, everything is there. Next slide. So memorializing and preserving the investigation evidence. We've talked about this a little bit along the way, but just in terms of nuts and bolts, I find that I'll get, when I step into an issue or I pick up a case where there's been an internal investigation done, the notes aren't always clear and they're not always preserved in the best way they could be. So I encourage people to take the notes however best suits them. Some people can't type and talk or think at the same time, or what tends to happen is, someone will just be and it's very distracting to be interviewed by someone who's just typing the whole time. That can be solved by having a person there as your scrivener, so that there will be more or less two interviewers. One person's there to take notes and also to remind you as the interviewer of questions you need to ask. That's really good for serious, complex investigations. But typically I write on a legal pad. I keep it, I have a line that I draw down, and I write at the top who the interviewer is, who the interviewee is, the time, the date, any other person present, and then I'll write the end time of the interview as well. I will have a line down the side so that I can write notes here and then have a follow-up column here. And at the very end of the interview, I count how many pages I have and I write 1 of 10, 2 of 10, 3 of 10, that kind of thing. Because I've been surprised at how frequently pages are lost of interview notes. I also go back and fill in the gaps. I very quickly go through and I fill in anything that I know is not going to make sense later. I clarify cryptic notes and I make sure that I can read my own handwriting, which is sometimes a problem. And I also make a credibility determination. I'll typically make that after the witness is left at the bottom, and I will write why. Why do I think, did they change their story a number of times? If you're going to base it off of body language or something like that, I would note that. I would be somewhat hesitant to make a credibility determination exclusively because of body language, because people do crazy things when they're nervous. But if somebody has an extreme physical tic, I will note that because that person could potentially be a witness. And my view as an investigator of what that tic means in terms of credibility or that sort of thing could be very different than what a jury's assessment of that credibility or what the jury's assessment of that tic is. And so to the jury who's been watching Law and Order, whatever, a tic may mean untruthfulness. To me, it's going to mean maybe nervousness. But I note that pro or con for our side, because I want to know that person, what kind of witness they're going to be later on, should this go to trial, or should they be interviewed by an even more serious body. And then I follow up immediately with company personnel on an issue that needs to be solved or needs attention. And so, for example, if there are immediate retaliation concerns, or if I discover that people need to be moved apart, I've actually stopped an interview before because I have been so concerned about what is going to happen. I did it kind of discreetly and said, I'll be right back, and then immediately followed up with human resources and an attorney within the company to make sure that two people were separated immediately, and then came back in. But there may be other issues that arise that you may not have to stop your interview for, but that need immediate attention. Next slide.
Hey, Susan, before we move to the next slide, quick question from the audience. Are you allowed to record interviews?
As the as the interviewer or the well, I'll do it both. Okay. I think that that's an issue that I'm going to slightly cover, but I'll cover it now. I always assume that the interviewee is recording. I just always do. As an interviewer, you can record. I don't usually. And there may be some compelling reasons to record, like, and this is very extreme, or even video, like if you have somebody that is on their deathbed and you need their testimony preserved, you'll probably want to video it. You might even want a transcriber there. You might want a court reporter. More run-of-the-mill investigations, I don't typically, because it's really hard to have to test or to assess credibility just from a recording. And you miss a lot of other things. You miss interactions, you miss, pauses become different. You may not understand the reason for a pause on a recording, but you understand in real life that that person is, taking a drink of water or looking through their notes. And on a recording, it may sound like the person is hedging, lying, whatever, and you just can't tell. The other thing is, well, I mean, to follow up on that, so it may bring your credibility determinations into question. If there is a concern that the person is going to come back and say, no, I didn't say that, have two people there. I think two people is the best way to ensure credibility and to ensure that you're not going to have someone come back and say, no, I didn't say that. And the third issue, though, also is if you are interviewing an employee in California, for example, or another state that you have to have two parties consent to the recording, be very wary of that. And also make sure that you say in the beginning, would you not consent to recording this? And if you are in a one state or a one person consent state, realize that you're going to be recorded. Does that answer the question? If not, whoever asked that, like, ping back with a follow-up question, and I can cover that as well.
Great, thanks, Susan.
Okay.
Appreciate it.
All right, thanks. Okay, next slide. So at the end of the interviews, I determine if there are additional questions for other witnesses. I edit up the other witness outlines. I go back to do I need to follow up with anyone? And I make any copies of the documents that I'm going to receive or that I received, if I haven't done it already, and that I'm going to use for other witnesses. As an attorney, I typically convert my notes to an electronic format and then shred my handwritten notes. I don't type them up typically, or I don't change them, because then you have a question of two different versions of whatever you've just done. So really, I just scan them. They're there if I need them, that sort of thing. And then I save under each witness. And I do that immediately, or I try to, because like I mentioned before, these things get lost. It's really crazy, but pages get lost, witness interviews get lost, and it's really hard, or it's really easy, I should say, to set that aside and then lose it. Next slide. Here we go. Record or not record. So I don't think I said the pro of recording is you have a transparent and open investigation. And depending on your investigator, there are some really bad investigators that are tempered by recording. Ideally, since you're going to be doing these, that's not going to be you, and that's not going to be an issue. Like I said, the con is if you record one, you should record them all, with the exception of the deathbed interviews. The other piece, though, that I didn't mention before is, just like emails, you're still creating another piece of evidence that could come in another unrelated matter. And so, I mean, oftentimes I've seen, this is the no good deed goes unpunished, and it will come in some other case as a piece of evidence. And oftentimes you'll have this, perhaps the same attorney represent a number of people, and so they know that this recording took place. That's another reason I don't particularly like them. And then, like I said before, it does allow for additional scrutiny of a variety of things, you know, like of your questioning style, of your tone of voice, of your whatever. So it allows somebody to come back up without a full set of information and question what you've done. Next slide, please. So in terms of documents, document your system for keeping the files separate and secure. You'll want, I mean, any kind of discrimination investigation, you'll want password protected, that sort of thing. You will not want this to go in somebody's personnel file so that, you know, like a junior HR person is just going to be scrolling around and find it, or a manager, for example. You'll want this only accessible to HR, and you know, the more high level it is, the more clamped down it needs to be. You're going to want to document how you obtained the evidence, like I said before. You'll want to preserve any of the original data, like metadata, for example. Always make copies, never use the original. And any document that has attorney notes, you're going to want to write attorney work product on it. And it doesn't hurt if you are communicating with an attorney, or if an attorney sees it, that sort of thing. In terms of future record readers, it sounds pretentious, but putting an ESQ at the end of that person's name immediately notifies whoever looks at that document that an attorney was involved in this, and that it's either attorney work product or attorney-client privileged. And so it helps down the road. Next slide. Before we discussed previously whether or not you want a witness statement for every witness, and it's really all or none unless there's a compelling reason. The one thing that I will note here, you should do it pretty quickly after the interview so that it's accurate and it's fresh in your mind. And then if the employee, when they're signing it, changes it, have them write out why they did it and initial it. And then if you don't think that they're telling the truth, do your own witness statement as well. Don't show that to them, obviously, but have it be part of the record. Next slide. The investigation report, I encourage you always to write one. These things have a way of coming back to bite you if you do not, because you don't know how you've tied it up. As an attorney, I destroy any working drafts of the report. If you are a state employee, you may have other preservation requirements under GRAMA, so go with those. And the investigation should identify basically who, what, when, where, why, investigator, company, the dates of the investigation, everything you looked at, every site you visited, the dates of those things. Next slide. It should include a summary of the issues, a statement of factual findings, the methodology used to conduct the investigation, and that's really just what all did you look at, and who did it, how did you do it, how did you preserve information. If you're a lawyer, applicable law, I mean, human resources can also put this in. If you don't know the law, I would get an outside attorney or your in-house attorney to help you write this. And then any recommendations. Next. The best practices for this, I know we're running out of time, so I'm going to speed through this, but explain the reasons for your determinations. And really, my note here is if it's not making sense, you've either come to the wrong conclusion, you have not included enough information and need to go back, or you're not dealing with facts head on. Oh, or it's just poorly written. That's always an option. But do not be afraid to just deal with bad facts head on, or things that you cannot determine. You must deal with those in your report. And you might not be able to come to a firm conclusion, and that's just part of investigations. Next slide. You want to be able to explain why you're reaching these credibility determinations and your ultimate conclusions. And you got to be able to convincingly do it. So if you're not, you need to go back and look at poorly written, enough facts. Am I ignoring bad facts? Am I just wrong? Okay, next section. And then finally, you want to legally and efficiently remedy the problem. And that could be, that is always going to be a determination of if anyone's going to be punished, measures to prevent reoccurrence, bringing in additional staff. You could have additional reporting, additional observations, a new auditing process, that sort of thing. And that's really going to be dictated by what it is you find. Next slide. These are the things that I just mentioned. The more serious the problem, the more likely you're going to have to do these. And I always, next slide, I always say that you should train. I mean, almost every investigation requires or hints at the need for additional training. So that is the end. Thank you so much. If you have any questions while you're doing an investigation, about a past investigation, while you're setting them up, please feel free to call me. I love investigations.
Susan, great job. Thank you very much. That was incredibly thorough. And thanks so much for preparing the materials for today's session.
Thanks.
Okay, well, we are at almost at the top of the hour. Tomorrow's session will begin at 8 a.m. And will run like today until 12 p.m. The topics that we will have for tomorrow will include issues ranging from marijuana in the workplace, telecommuting, masks, vaccinations. We will focus also on Utah's non-compete statute, celebrating its 25th anniversary. We'll touch on professional work visa options, and we'll wrap up tomorrow's session with FLSA and regular rate of pay calculation. So I want to extend a big thanks to all of you for spending your morning with us, and we look forward to seeing you at 8 a.m. tomorrow. Should you have any questions, please feel free to reach out to us or visit our website for more information about the seminar. Again, thanks so much for joining us. Have a great afternoon.